The Worker Adjustment and Retraining Notification Act, or WARN Act, requires employers to provide 60 days advance notice of plant closings and mass layoffs. The act only applies to employers with 100 or more full-time employees. That's why the laid-off employees in Childress versus Darby Lumber argued that the two companies that employed them were really a single entity. Darby Lumber operated a lumber mill and sold finished lumber. Darby acquired all the shares of Bob Russell Construction. Russell did construction, hauled timber, and managed Darby's log yard. Darby had 88 employees, and Russell had 18. After suffering some losses, Darby informed its employees that the company was in financial difficulties and to expect major layoffs. The next day, Darby shut down the mill and laid off all the mill employees. The rest of the Darby and Russell employees were laid off over the next few weeks. Sharon Childress and other former Darby employees sued Darby. They alleged that Darby had violated the WARN Act by not giving them 60 days' notice of layoffs. Darby and Russell countered that the act didn't apply to them because each company had fewer than 100 full-time employees. The district court found that Darby and Russell were a single employer for purposes of the WARN Act. It awarded the plaintiffs the 60 days' pay they would have earned had they been given adequate notice. Darby appealed to the Ninth Circuit.